Hello everybody, I am Madhulika, a Senior Patent Associate at IPLF. This webinar, titled Tips and Tricks to Search a Relevant Prior Art on Various Databases, is being presented on behalf of IPLF. The session will be bifurcated into two major parts. In the first part, we'll discuss about the basic concepts and the terminology that is to be used on various databases for finding a relevant prior art. While in the second session itself, we will be covering the questions that could be asked by the participants. So, what actually is a prior art? A prior art is any evidence that your invention is already known. A prior art does not need to exist physically or needs to be commercially available. It is enough that someone somewhere, sometime previously has described or shown or made something that contains the use of the technology that is very similar to the invention we are planning to get patented. That could be a piece of technology that is kind of centuries old, that can act as a prior art for our invention, a previously described idea that cannot possibly work can also be a prior art. So, considering the market scenario, anything that is available in tangible or intangible form can be considered as a prior art. Also, an existing product is the most obvious form of prior art. This can lead many inventors to make a common mistake. Just because they cannot find a product containing their invention for sale in any shops, they assume that their invention must be novel. The reality is very different. Many inventions never become products, yet there may be evidence of them somewhere, hidden. So that evidence, whatever form it may be, wherever it may be available, we need to fetch that out and check its validity against the invention that we are trying to get patented. Another important criteria that we need to keep in mind is the competing art. While looking for a relevant prior art, we should also look for the competing art that is available in the market. Now, what is a competing art? These are the ideas that may not be at all like what your invention is doing, but it does the same job as being done by your invention. Also, it is important to study competing art for two very relevant reasons. First, most inventions are a solution to a problem, and most problems have more than one possible solution, and we all agree to it. So, what do we need? We need to examine other solutions as some may offer more advantages than yours. That means the advantage that our invention is offering for a problem has multiple solutions, and some better solutions are already available in the market, and we need to look out for them as a part of a competing art. Next important reason is that if we are trying to exploit our idea commercially, alternate solutions may be a strong competition for our thought of novelty. So in order to argue successfully that your solution is better than alternatives, you need to know what the alternatives are. Not wasting more time, we'll switch to the presentation. Now to start with, what is a prior art search? We've discussed about what is a prior art search, why do we actually need to have a prior art search done, and also look at the competing arts that are available in the market for better feasibility of obtaining a patent on our idea. Now, who all needs a prior art search to be done? A new inventor, if he or she wants to know that is their invention novel, or who already owns it, or who are the competitive assignees or inventors are there in the market, they need to go and get a prior art search done before getting their idea being converted into a patentable form. Next, before filing a patent, an inventor or an assignee would like to know about the prior art search, if any, exists in the market for their novel invention for which they are planning to get a patent. So before filing a patent, the inventor may wish to perform a prior art search to make sure that on the day of filing patent application, his invention is novel and there is no existing patent or publication of the invention before his date of filing. Also, the prior art search is done during the opposition or the revocation process. This is mostly associated with the prosecution related matters that are handled at the patent offices. Now, during opposition or revocation, if anybody wants to oppose or revoke the patent application or a granted patent on the ground of lack of novelty, a novelty search needs to be performed. If any publication or patent is found to exist before the date of filing of a patent, such patent may be opposed before or after the grant. Therefore, novelty search is important to impose the patent application or revoke or invalidate a granted patent. Next, if you want to perform a product launch, in that case also you need to perform an exhaustive prior art search. The companies may perform prior art searches before launching their products in the specific markets to make sure that they are not infringing the rights of any third parties that may be having a patent likely to be infringed by their product launch. So prior art search helps to reduce the risk of infringement of patent rights by the third parties on your products that are launched without performing a prior art search. This search is also called as the freedom to operate search. Why it is called as the freedom to operate search? Because it gives a party enough freedom to launch their product in the market without infringing on the rights of a granted patent or a granted set of claims. Now, the searching process could be performed of multiple kinds. Few of them are the patentability search, freedom to operate search, validity and invalidity search, state of the art search. Why are we discussing about the various kinds of patent searches? This is important to understand that each search that is performed at various stages of the life cycle of an invention, maybe that is done before getting into the launch of your idea as a product or as and then after your patent has been granted, what kind of a search is done so as to withstand its strength of the claims in the market. All that has to be taken care of during the life cycle of the patent. So at various different stages of the life cycle of the patent, various different kinds of searches are performed. We'll discuss each of them. First is the patentability search. So at each step of the innovation, a lot of ideas that are given by the inventors, they look to be very unique and patentable. And we all know that huge investments go into the development of new ideas and products. So a proper assessment of the technology is required to design further research or expansion of the existing thought of a inventor. And so prior art searches in that domain help a lot. So when a company or an individual inventor spends a lot of time, money, and energy in development of a new idea, it becomes very essential to analyze the novelty and scope of the inventions prior to filing a patent. So a quick novelty or patentability search in the technical domain helps make the effective decisions of whether to go ahead with filing the patent or not. And this definitely helps save millions of dollars for the inventors and the companies. Next is the freedom to operate search. Before any company begins commercialization of their product or technology, they make it essential to conduct a FTO search so as to ensure that the desired product can be safely launched in a specific market. Market could be a specific country or certain regions of the country where their product could be launched without infringing on the already existing prior art products or patents. So this also helps to avoid the third-party intellectual property rights within the specific jurisdiction under which we are planning to launch our product. Now, it can be conducted at any product life cycle to determine the direction and the scope of our product growth and launch in the market. So, this freedom to operate search comes in handy if there are valid intellectual property rights of someone else that might be infringed by your product that you are planning to launch. You could also get the freedom to operate with respect to any of those rights by reaching some sort of agreement or a license with the owner of those IPR rights. Next comes the patent validity and invalidity search. Now, these kind of searches are conducted to either validate the claims made by the patent or to invalidate one or more claims of a competitor's patent. Now, this is the very first step that is taken by an individual inventor or an organization when they are faced with the patent infringement lawsuit. Validity searches are also conducted to check the strength of a granted patent while exploring the available licensing options by the one who has probably infringed on to your available patent. And now what is an invalidity search? An invalidity search is also another kind of a prior art search which is done after the patent is issued. Now the purpose of the invalidity search is to find a prior art that the patent examiner overlooked so that a patent can be declared invalid. This is mostly done by the competitor assignees that are available in the market that wish to invalidate your set of claims over multiple reasons. So this also helps the client to challenge another patent. That means it helps to invalidate the another's patent or be to prepare to defend a patent infringement allegation by a competitor. So in both the cases, we can either go for a validity or an invalidity search. Last is the state of the art search. The state of the art search is the broadest and the most general of all types of patent searches that is performed, and that is the one we have discussed right away. It is very essential for an individual or an inventor to find out what technology already exists there in the market. Now, the state of the art searches are very valuable in most of the situations of research and development. And it is important to a client who is contemplating entry into a particular field of art to understand the state of the art of that particular domain so as to take a decision. To a client who is currently available in a particular field of art, the state of the art search results can lay out the path that must be forwarded to design around the current art. Knowingly what work has previously been done, what problems have been discovered, and how they have been solved who is active in the field of art, and the chronological development of their work can prevent wasteful investments of time, effort, and money. Now, before starting any of the prior art search that needs to be performed, we need to plan the search strategy. Planning of a search strategy helps to maximize your chances of finding relevant information. Spending less time of thinking of keywords leads to spoiling of your search results. So the first and the foremost important point while planning your search strategy is to find the appropriate keywords that best describe your idea. Why do we need that? Because when using search engines, the most obvious keywords may be unhelpful. Why? Because they only help you to broaden your search results, and the search has to be performed in a limited scope of time, and scanning n number of multiple results in a limited amount of time would be really difficult for a searcher. So we need to get the core keywords of our idea and design a search query around it so as to reach the core invention idea clearly. Another problem is that the most productive search terms or the keywords that may be known by a specialist are not known by a particular person. Why? We'll take an example. A search for external devices that pump blood around the human body require the crucial medical term being used as extracorporeal. Now, a searcher with no medical background would unlikely to know this term, but might find it while examining the results or other keywords searches that he or she has done. So it may therefore take a few preliminary searches to find better keywords to use for more accurate searches. Why are we talking about this concept is because when we start the search, any new idea that comes up is very raw, and after we start using the very basic keywords around, we start getting some relevant results, and we build upon those search results by extracting the keywords, the classifications, the assignees, and the inventors from them, so as to build up on our search and use those results so as to refine our search strategy further. Next is the concept approach. What actually it is? A prior search usually boils down to a combination of concepts defining the subject matter you're looking for. Concepts can be retrieved by imagining different texts describing the same invention. And in these different texts, you will necessarily find words expressing the same concept. Knowing that the documents you're looking for have these common features, these so-called concepts you search will consist in finding these documents where a given combination of concepts is present. And so a concept can be perfectly expressed as a set of inventor plus assignee plus classification and keywords being used so as to reach to a conclusive set of search results. Moving forward, we will take up an example where we need to find out a prior art about techniques that prevent the use of mobile phones in public areas. We know that in public areas, usage of mobile phones is quite common. So we need to find out techniques where the use of mobile phones in public areas such as schools, colleges, hospitals, libraries, cinema can be avoided by default. So what all concepts can be derived from this set of invention? First is the mobile phone itself. Now, as we discussed in the previous slide, that we need to first find out the appropriate keywords and then we need to build on the concept approach. So here we'll see that how are we building on the concept approach using the keywords. So the first keyword is the mobile phone. We can use phone, wireless phone, cellular phone, cell phone, or digital phone as the synonyms for the mobile phone. Next is the concept is of the reducing noise. When you are using a mobile phone in a public area, it leads to noise and disturbance to the another public around. So the synonyms could be disturb, turbulence, or noise. Next concept is public room that we have taken up from the invention idea itself, public room or public areas. The synonyms there could be hospital, cinema, public areas, petrol pump, library, etc. The last concept is prevent. We need to stop, deny, restrict, block, avoid, limit, inhibit the use of the mobile phones in the public space. So we would be using these set of synonyms along with other discussed concepts used for searching a prior art to look out for a relevant prior art in this domain for this idea that we have talked of. Next, coming up to the kind of operators that are used when we are performing a prior art search using the keywords. Now, there are so many keywords that we discussed in the previous slide for each and every concept. To use all these keywords in one go, or in as a combination, or as inclusive or exclusive of each other, we need to use a set of operators that are available at multiple databases and are used extensively similar form across all the databases. First is the AND operator. It helps to include the results that has both the set of keywords in the search results. OR operator helps to get the search results where you have one of the keywords present in the search results. And NOT operator basically helps you to leave off a set of keywords that you don't want to see in your search result. The example could be, I want to see search results related to mobile or wireless, but where I don't want to have the word phone. That kind of a technology I'm looking for, where I have mobile or wireless concept being discussed, but usage of technology of phone is not desired. So I have kind of combined all of these operators and prepared a search query which says that I need mobile or wireless and not phone. So this example also shows that we can use a combination of these operators to reach to a search result. Next is the set of proximity operators. We can have multiple set of proximity operators performing some jobs for us. These proximity operators could be near, WF, W, N, adjoining. So this N here basically refers to the search of words that occur within a specified number of words of each other in a database record. So if I want to find out something like mobile, which is not related to a wired technology, or a phone that is not related to a wired technology. So I'll use phone, WF, N, and N I'll replace with the number of words to the word wire, and then use this along with my keywords. Last are the truncation operators. Now these are the various truncation operators that have been mentioned here and are used in various databases in different forms, and they basically provide all kinds of possible spelling or variations that are available inside a word stem. An example could be if I use something like compute star, so it will give me all the search results related to computer, computing, compute, etc. So we can use these truncation operators accordingly. So building on to the idea of novelty that we were discussing here as an example, I have created a search query to the similar idea we talked of, that we want to prevent the usage of phone in a area. So what I have built a very broad query here, which says I've used kind of all the available synonyms in the search query, and I have built a search query on a free patents, that is also known as the free patents online. It's a freely available database used widely across. So the search query says that it could be a mobile phone or a wireless phone or a cellular phone, and when it is being used as a noise or a disturbance, and again where it is being used in public or hospital or petrol or library, what do I want to do? I want to stop, deny, restrict, or block their operation. So as you can see, as highlighted, we got something around 74,700, 800 results. Now that's quite a lot of results for an individual to scan. So we tried narrowing down our query. This is also one of the approach that a searcher usually follows. We should always try and start our search in a broader form and then narrow it down to the specific set of keywords. Why this is advised is because it helps you build onto your search query, all in terms of getting information for assignees, inventors, classification, and also in terms of the various jurisdictions in which the prior art might be available. So here we can see that I have used an operator, this question mark here, restrict or deny. I have not used why, and I've used operator. And then I have used another set of uh, and ors to limit the number of search results, I have removed some of the keywords there. And so the search results have drastically reduced from 70s to 44,000. But still, this is quite a lot of results. We'll see how we can refine it down. Same query I performed on Google Patents, and we could get some set of results, 5,250. And again, we tried narrowing down the query, the same narrowed query we performed on Google Patents, and we could bring it as down to 520 results. As you can see in the extreme left part of this screen, we have used the proximity operators here, that is adjoining and near, so as to narrow down our search results. Also, we have reduced onto the number of keywords that were used initially. So after performing this query, Google helped me retrieve a couple of relevant prior art searches. We'll discuss few of them. First was a targeted mobile terminal communication blocker. So what we can understand out of here is that all the keywords that were available would have helped target us to reach to this search result. So we have to use our set of keywords very judicially as a starting phase of our prior art search and then build onto it. So just by reading the track, it looks it's a relevant prior art. It says a selective blocker for a targeted mobile terminal. A signal monitor determines when a targeted mobile terminal is transmitting a signal to a base station. A signal analyzer defines characteristics of the terminal, and the processor produces a blocking response based on one or more characteristics. The blocking response is transmitted to the targeted mobile terminal to block the communication between the targeted mobile terminal and the base station. So here comes the point of blocking. If we just look around this search result, we can make sure that just using some specific keywords of block, deny, or school or something, we could not have reached to it. After performing uh, the use of the operators and the keywords judicially in combination have helped us retrieve to this search result. So the claim is also proof of this, that the search result is quite relevant here and is shown as highlighted. The claim clearly shows, the last part of it says that it transmitting of a blocking signal comprising the blocking response of the response signal frequency and the blocking signal power. So the mobile terminal has been blocked under when a certain set of conditions were satisfied under this case. Now, on the left part of the screen, we have talked about a few classifications that were shown on the Google search page itself under the results section. Just keep a record of it that we looked onto the classifications, and we'll discuss it later on. Another patent searching tool that could be used is to look for the citation search. Now, the search result that we obtained previously, we just discussed, had certain set of citations being provided, and it says patent citations. And we also had something like cited by. Now, what is the difference between these? Because citation search is also one of the kind of search that needs to be performed, and it is very helpful when we are performing a validity or an invalidity search by applying the date constraints, and we are mostly able to get a very relevant closer prior art by using the citation search. So the patent citations, now these are the set of patents or the publications that were used by the inventor to build his search over and get a grant over it. And the asterisk signs that you can see on the publication numbers that are displayed in blue shows that all these references were examined by the patent examiner and the inventor has countered his invention over all the rejections seen by the examiner over these prior art, mostly all of them, and has obtained a patent over his invention. So the asterisk sign says that these are all the cases that have been looked up by the examiner. Coming up to the cited by, obtained on your invention, there would be some further inventions that would be made over to your invention. Now, the ones who will build over your invention will cite your case as under patent citation. And so these are the set of uh, cited by references that would be used by the another inventor to build over their search. There is another search result on the idea that we discussed, and this also says that there were some sensors installed in the device and the use of the transmissions for identification and determination of whether a device is within a restricted area. Now, this is what we were looking for, that if the device is available within a restricted zone of the ones we discussed of, in that case, the controller sends the device identification and possibly a customized restriction request to a remote node, for example, a control node of a cell phone network operator. So this is very close to what we took up as the invention idea. The claims are also a justification of the same. And here also, please keep a record of the set of classification searches. Next is the assignee and the inventor search. Now, what are these? An assignee is a person or a corporation a patent has been assigned to. An assignee could be a bigger company or a corporation to which a patent has been assigned. And in the case of an independent inventor, assignee and inventors are same. So, looking at it, we have formed an assignee search here on the free patent online by using the keyword AN. AN stands for assignee. So for the similar invention idea, we have tried and performed the search related to the assignees. Probable assignees could be Samsung, Google, Apple, or whatever we have built on from the search results that we have obtained. We have used them to reach to a conclusive point of the search results. Now coming up to the classification search again. We had talked of that we electromagnetic interference in petrol station, hospital, plane, or city. So as we can see, this class clearly maps on to the idea that we had to look for as a prior art. So if we can know about the classes beforehand, we could just get the prior art search within a span of few hours. But reaching to this classification can be done under various methods. First, as one we discussed, that we used a set of keywords using various operators, and then we extracted the set of classifications from it, and then we will build onto our search query to be used later on. Or otherwise, we can get the classification search being formed under the European Patent Office to get the classification in one go and then use that classification for searching. So it depends on your searching technique or strategy, how you want to build over your search. Another classification that is of interest on this slide is H04K3/42. Now this is a jamming classification having variable characteristics that is characterized by the control of the jamming frequency or wavelength. So If you control the jamming frequency, the device will stop operating under set of conditions. So we can use multiple databases for performing these set of operations. I told you about few free databases that are available. The paid databases Orbit, Fatbase, etc. Now let's talk about the EPO search process. As you can see, here we have techniques of performing a smart search where we can just use a set of keywords and then obtain a set of search results that are relevant to a search query. And if we have a lot of information available at our disposal, or maybe we have built onto our search queries, we can use those set of keywords to perform our search further. The first block is use title. Here we can use a set of keywords separated by comma, and we can use up to 10 keywords to perform a search. This will only help you find relevant art, that is having those set of keywords under their title. If you want to expand your search, you can use the set of keywords under the title or abstract idea. Here too, it has to be separated by a comma. Next, we can enter the numbers with or without the country codes and as relevant as per the mode in which they are to be used. And then there, the concept of using a cutoff date arises. Next is if we want to limit our search on the basis of the applicant or on the basis of the inventors. Now, suppose if I am working on a technology that involves uh, mobile data or a mobile structure being used for communication. So we all know that the players like Samsung, Google, Apple, Nokia, they are Huawei, they are the key players in this domain. So we can use those applicants in combination using or and that will help us narrow down our search result and will help us reach to a closer priority. Next comes the inventor. The set of inventors, if we have knowledge about, could be used to reach to a conclusive point using the keywords and another set of search strategy to reach to a priority. Next comes the classification symbols. So if we know about the CPC classification as we just discussed, we can just reach to the search result very quickly. Same is the case with the IPC search. So this is a search form, advanced search form that is used on EPO, and EPO is a very extensive database and help you get search results across various jurisdictions under one page. And now the IPO cases are also listed under the ESPANET databases and can be looked on for to check their relevancy as being a prior art or not. Next comes the classification search. Now, this is an interesting area. Suppose if I am looking for something like home automation and I have the knowledge about the class. So I'll just enter the class and it says that I can interact with the home and the control can be done using a remote control operator. As we discussed that the CPC is divided under as being as a section class. So we have a section, then we have a class, subclass, group and subgroup. So as defined. Also, we'll take another example. If we know about another classification, it will help us reach to the closest level of our search result. Okay, we'll search broadly and then we look out for the smaller search results. Okay, here it goes. So it says that there is a transmission of digital information that is being done on a network, and the various other subclasses are provided under it. So this could be used under various ideas that we are looking for a search. Here, what I showed you was like I knew about the classification and it helped me reach to particular classification in one go. But suppose if I have a keyword in mind. So what I typed in is a windmill, and clearly it takes me to a classification with the description energy generation through renewable energy sources, and then comes up controlling wind motors and its components. We can expand and reach to the smallest element on which we are working on. As we can see, the depth of detail each classification has in itself to be used so as to fetch a relevant prior art. So this is how EPO could be used. Again, as suggested, we can fetch a relevant classifications from the uh, search results that we have obtained earlier, or we can look out for a keyword in Wikipedia or Thesaurus, and then we can use them, or we can also build on to the CPC search using the relevant prior that we have obtained to maybe go closer to our prior art that we are looking for. Also, we can come to Espanet and search a CPC, a relevant CPC, using the most relevant keyword that is available for our invention, and look out for the closest CPC and then use it directly to build up upon our search further. Next, will discuss about the Google Patterns. It's a freely available database. Now, as we can see, we have a various set of search fields there. We can enter our search terms as keywords. Maybe if I add like home automation. Now it also tells me that I can use an operator or add another synonym for it. Okay. Additionally, it says plus synonym. When I say plus synonym, it absolutely conveys the clear meaning that I want a home automation device to be used along with another set of keywords. So what it could be, it can be voice controlled home automation device. We can add another set of synonyms to it, or maybe I say here or audio. So it says or audio, okay, or if I say I want to use gesture to control my home. So it will help you build your query. As we can see, the query is being built in the search query box at the top of the screen, and we need not put in the braces under which we kind of commit some mistakes mostly. So we can just enter very conveniently our search terms under this section, and it will generate a query for you. Also, you would have noticed that when we were typing the search results, when we were typing the search queries, the classifications related to the relevant keywords that you were entering were being shown corresponding to the keyword that you entered. So we can also use the classification right here, read about it, and maybe again use it in combination with our keywords or the assignees or the inventor or as a citation search and reach to a closer prior art. Okay. Next comes this another set of search fields. As we discussed in ISPASnet that you could perform a search on the limitations of being categorized under a certain set of dates. Here also you can prioritize your search results to be lying under certain set of date criteria, and the dates are to be entered as YYMMDD format. You can ask to be entering date as from maybe as before as 1980 to a present date to look out for a relevant prior art. Again, here inventor, we can add a complete list of inventors that we have in mind to be looking for a relevant prior art. Also, the assignees, as we mentioned, the assignees and the inventors could be common if it's a small entity. Otherwise, for a bigger organizations, the inventors are mostly different from the assignees. So, as per the kind of search that we have built up or the depth of search that we want to perform, we can enter the search queries. Now here comes an interesting section that we can limit our search to certain jurisdictions as listed under Patent Office as US, EP, WIPO, China, JP, so on, Korea, so on. Also the language part in which you want the results are also available under this Google Patent databases. Next is the status. Suppose if we are only looking for the granted patents and not the applications, we can also select that. Next comes the patent or the design. If we are looking for patents, then we can select the element patents, or if we are for performing a design search, we can look for the design part of it. So we are like kind of done with the details of the search techniques to be shared, and we are ready to take the queries. Let's see if we have. Next question is, can we combine proximity operators in keyword search? Yes, for sure. Proximity operators should be used along with the keywords so as to fetch a relevant prior art. And also it helps to reduce, obtain the search results. Another set of query is that which database is considered a better database, be it a patent paid database or a free available database. So depending on the amount of the time query. We have still not received the detailed question that was asked up. I think we can take the rest of the queries on email. Um, if any of you have any further queries related to the use of operators or classifications or assignees or inventor search, please feel free to send an email across and we'll be happy to help you.